the general bail on no less than 12 occasions. The former Lieutenant General, Mr. Derby, has for many years faithfully served His Majesty and the people. And the reason why this press conference has been called is as stated. I shall, during the course of this press conference, refer to the former Lieutenant General simply as the former General. I mean no disrespect by shortening the appellation in that manner. But I apologise for conducting this press conference in English. I cannot speak Arabic, and I hope you will forgive me. I will first of all address the Jordanian anti-money laundering legislation, which is derived from certain European Union directives and implements, amongst other things, the Warsaw Convention. I'll then describe in practical terms how the legislation impacts on the preparation of the defence of the former general and the charges brought against him. We will then examine the delay in this case and the history of the investigation so far as it is pertinent. Lastly, we will look at the circumstances regarding the refusal to grant bail, and most importantly, look at that in the context of the effect of the trial preparation. At the end of my address, I will make an announcement of the steps the former general is prepared to take to clear his name. I will then invite questions. You will appreciate that the hands of the general's lawyers are tied and will not participate, except to clarify any points of law and procedure. As you appreciate, I'm not a Jordanian lawyer. I have been instructed because of my experience and I suppose expertise in international money laundering matters, which goes back over 20 years. Any error or misstatement is my responsibility and should not be attributed to the former general, his family, or his lawyers. The legislation. The legislation's history was brought about as a result of the steps taken by the United States and the European Union in developing an international code which is designed to defeat the movements of funds by organised crime and international terrorist groups. It has been enacted in virtually every country in the world who seeks to conduct trade and international commerce, and is designed to inhibit the movement of funds internationally, because that is typically how money launderers work. The enactment into Jordanian law was first in 1993 in the Economic Crimes Law. It's now been amended several times, as I understand it. Articles 3 and 4 are instructive, and I'm sorry if I concentrate on some points of law to start off with. It's important to understand the juridical foundation of the charges that the former general is facing. Article 3A reads as follows: "It shall be prohibited to launder the money gained by committing any of the crimes provided for in Article 4 of this law, whether the same shall occur within the kingdom or outside. It provided that the act should be subject to punishment provided pursuant to the law applicable at the country in which the act shall be committed. It shall be prohibited to advance money, raise or secure the procurement, transfer of the same, whether directly or indirectly, and even if the same shall be realised from legal resources to a terrorist or to a terrorist organisation, commission, society or group, or otherwise for supporting a terrorist act knowingly, and whether the said money should be partially or totally used, and whether said acts shall occur or not." That essentially is the prohibition against that conduct. And explained in layman's terms, it means you cannot deal in any way whatsoever with the proceeds of crime. The important emphasis here, ladies and gentlemen, is of course based upon the proceeds of crime, which means any money or property which has been derived as a consequence of the participation in unlawful acts. Those are the usual crimes about which you report in your media every day, and they're set out very clearly in the proceeds of crime. This is the essence of the offence. It does not need to prove which crimes generated it, or that the person accused of money laundering was in fact involved in those crimes. It's quite a separate offence. This is therefore a broad and powerful weapon which has been used in a number of overseas jurisdictions, I emphasize the fact overseas jurisdictions, by prosecutors as an instrument of oppression, because that particular section is repeated in almost every country in the world. As it's a separate offence, and there's no obligation upon the prosecutor to prove that the individual who's holding the money is doing so as a result of his commission of a particular crime. It is sufficient to prove that the money in question is in fact the proceeds of the crime. This has led to a significant judicial conflict amongst many nations, and I personally was in the Supreme Court of the United Kingdom last November, arguing on behalf of a citizen of the Mauritius Island, because the Supreme Court of Mauritius had declared that the Economic Crimes Act in that country, which is very similar to your own Economic Crimes Act, in fact was unconstitutional, because it deprived the subject of that investigation the usual defences he was afforded under the Constitution. The Supreme Court in the United Kingdom came to the conclusion that to hold that particular statute unconstitutional imposed an unreasonable fetter on the discretion of prosecutors when they were seeking to bring the matter before their courts. However, the Supreme Court in the United Kingdom decided that it would pass comments upon the matter by saying that it was incumbent upon prosecutors of Mauritius to ensure that no injustice was thereby caused. Now I say a few remarks about money laundering generally. I have been involved in dealing with the consequences of allegations of money laundering in both the civil and criminal courts in the United Kingdom and elsewhere for over 20 years. And money laundering, in my experience, is typically structured as follows. It involves the concept of layering, by which different sums are placed in different companies and then transferred amongst themselves in order to give an impression of legality. It involves the frequent creation of false documents. It involves frequently the use of overseas jurisdictions into which dummy companies receive funds which are then transferred out into other dummy companies before they emerge as a legitimate source. I don't know how many of you here are familiar with the term Smurf. There was a regrettable cartoon series in the 1970s involving small blue men who used to be very busy, apparently doing nothing. That was the joke. It was the point of the cartoon. Americans, in their infinite wisdom and charm, decided that they would call smurfing, which is the depositing of very small amounts of currency in a variety of banks, named after the very busy blue cartoon figures. And smurfing is a typical and frequent example of how money launderers go about their business. The point of money laundering, ladies and gentlemen of the press, is to give the impression of legality once the sums have been laundered. It is, in my experience, unheard of a money laundering charge to be brought in respect of a single bank account in the name of the person under investigation, where no funds are being transferred, or the transfers are simple and explicable. It's, as I said, beyond my personal experience. Perhaps there have been other such cases. Which, I suppose, begs the question of why the prosecution is now being mounted. I'll turn now, if I may, to bail. I understand that there have been 12 applications and 2 appeals within 2 months. The defence team is in the middle of mounting another application for bail. Speaking as a foreign lawyer, I hope I commit no discourtesy in making these observations. I find it difficult to see why bail is refused. I'm sure the honourable judges have very good reasons for doing so. However, my understanding is there is a presumption in favour of bail in this country. Onerous conditions such as surrender of passport, ban on foreign travel, ensure investors see at appropriate addresses and where appropriate reporting of all of them. It cannot be said in all seriousness that the former general is a flight risk. There's no risk to justice or security by his release. Most importantly, the monies in the account in question, which constitute the vast proportion of the former general's assets, have been frozen. If not admitted to bail, when the general is acquitted and his good name restored, he will have served the equivalent of a substantial period of imprisonment. My understanding is it's contrary to your constitution, and it may be instructive to refer at this point to Article 101/4 of the Jordanian Constitution of 1952. The accused person shall stand to be innocent unless proved to be convicted by definite order. This is a classic statement of the presumption of innocence.
I just wonder whether this kind of press conference, a kind of a political pressure in a case that looks like a legal case. I wonder if you could comment on the issue of the political aspects involved in a case that involves one of the former most powerful guys in the country. Thank you.
Well, I wouldn't comment on a political matter in my own country, much less as a guest in yours. Next question. So, the gentleman behind you were first, I think.
Well, thank you very much. My name is Hassan Barai. I just want to follow on the question raised by my friend Khalid. So if you really can't answer any political question, there are a lot of people in this country think that the whole trial is political. And I don't want to ask you this question, but I just want to probably pick your mind on the issue that why the lawyers have failed to get his bail. Thank you.
I really can't answer that question. It's probably a better question to be directed to his defence team than myself, as I wasn't present at the hearings. I think they're probably going to maintain their dignity in the circumstances. I can't blame them, as they have to appear in front of the appellate court shortly on a renewal of bail. However, the considerations that apply to all bail applications are well known, and the investigation is ongoing, and frequently and quite properly a good deal of latitude is given to prosecutors by judges, and one must respect that. No doubt the honourable judges will give anxious consideration of this matter when it returns to their court shortly. Next question. Yes, General Beard.
Please, you can translate me, Mr.
Yes, you translate.
أنا الإعلام شبلي حداد. عن الإعلام شبلي حداد يقول إن هناك في غسيل أموال. يقول هناك في غسيل أموال من قانون عمل من القانون 4 و3، ويقول أنه هناك إن غسيل الأموال لا يشكل خطرا على أمن الدولة. هل هذا صحيح؟
If your question, sir, is that does money laundering endanger the economies of countries in which it is practiced, the